Hello, everyone, and welcome to this series on the Texas Code of Criminal Procedure. My name is Reese. I'm a licensed attorney here in the great state of Texas. And the reason that I'm making this video series is I remember back about a month ago when I started my company, started moving into criminal defense, and I was looking on YouTube for the Texas Code of Criminal Procedure, and I wanted to see the videos that were talking about the Code of Criminal Procedure. And I know that this would have been useful, and it's just something that I haven't found on YouTube. And in addition to that, because I'm going into the practice of criminal defense myself, I don't think it hurts for me to be very familiar with the Code of Criminal Procedure. So, guys, if you are studying for the bar exam or you're studying in law school, Texas criminal law, I think this would be something useful for you. The primary purpose of this video is just for me to go through the Code of Criminal Procedure, but I decided, hey, why not have some fun and go through the criminal procedure together? Gives me something to do. I will tell you that I find making these YouTube videos to be pretty therapeutic for me, so it's just who I am, guys. I'm very bookish, and it's what I like to do. So what we're going to do is go through the Code of Criminal Procedure, and I'm going to make a playlist on the Texas Code of Criminal Procedure, and we're going to start from Article 1. We're going to get through the two titles of the Texas Code of Criminal Procedure, and hopefully y'all find this playlist to be useful, guys. Okay, guys, so if you're wondering where we are here, we are on Fast Case, which is a Texas State Bar provided a legal search provider, kind of like Lexis or Westlaw, except it comes with your state bar membership, meaning it doesn't cost an arm and a leg. It's actually free with your Texas State Bar membership. And all right, guys, so I don't think these videos are going to get, all kinds of views, but it's really more or less just for me to learn. But I'm hoping that, hey, maybe somebody wants to come along and you'll enjoy it, guys. So, all right, so we're getting started with this playlist. We're here on Fast Case, and we can see the Texas Statutes 2023 edition. Now, guys, sometimes these laws do get changed, so the code changes itself. So the Code of Criminal Procedure might be updated in 2025, 2026 if there are new laws, different laws passed. Okay, guys, so we're here on the Code of Criminal Procedure, and we can see that that's right under the Civil Practice and Remedies Code. And we're going to start here with Chapter 1, the short title. This act shall be known and may be cited as the Code of Criminal Procedure. And we can see in our legislative history that this was first passed in the 59th Legislature of Texas, and it can be found in Volume 2, page 317, Chapter 722. And this act came into effect in 1965. So that's your legislative history. So that's the short title. And then we have 1.02, effective date. This code shall take effect and be in force on and after January 1st, 1966. The procedure herein shall be prescribed. The procedure herein prescribed shall govern all criminal proceedings instituted after the effective date of this act and all proceedings pending upon the effective date hereof, insofar as are applicable. Okay, so up here on the right of the screen, I'm just going to keep going through. Severability, this is Article 1.025. If any provision of this code or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of the code that can be given effect without the invalid provision or application, and to this end, the provisions of this code are severable. So, guys, this is something that it's interesting to find it right in the Code of Criminal Procedure, but this is a basic contract clause called severability. So if you have a provision in a contract that case was being litigated, the court might find that part of a contract is unconscionable or unenforceable for whatever reason. Might be a contract provision against law, or it might not have sufficient consideration. And so oftentimes when you're reading a contract, it's going to have a severability provision. So if that one clause in a contract is held invalid, then the others remain in full force and effect. Otherwise, the court potentially could throw out your whole contract. So that's where severability comes in, and it's important that it's written down like this. Okay, Article 1.026, construction. The articles contained in Chapter 722, and that's SB is Senate Bill 107, Acts of the 59th Legislature, Regular Session, 1965, as revised, rewritten, changed, combined, and codified, may not be construed as a continuation of former laws except as otherwise provided in that act. And so that this provision was added by Acts 2019 from the 86th Legislature. So we can see that this was added in 2019 and then it came into effect in 2021. You can probably assume that there was some portion of the Texas Code of Criminal Procedure before that was held to be invalid. There was probably some criminal case that held something to be unconstitutional, which is probably why this is there. Okay, guys. Objects of this code, and this is 1.03. This code is intended to embrace rules applicable to the prevention and prosecution of offenses against the laws of this state, Texas, and to make the rules of procedure in respect to the prevention and punishment of offenses intelligible to the officers who are to act under them, meaning police officers or peace officers, and to all persons whose rights are affected by them. It seeks, 1, to adopt measures for preventing the commission of crime, 2, to exclude the offender from all hope of escape. Oh, boy. 3, to ensure a trial with as little delay as is consistent with the ends of justice. I like that. To exclude the offender from all hopes of escape. Okay, I didn't realize that was written right into the intent of the code. Number 4, to bring the investigation of each offense on the trial, all the evidence tending to produce conviction or acquittal. 5, to ensure a fair and impartial trial, and 6, the certain execution of the sentence of the law when declared. All right, and then we can see that that came in originally in 1965. Due course of law, 1.04. No citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disfranchised, except by the due course of the law of the land. So, guys, this is going to mirror your Bill of Rights, the first 10 amendments to the United States Constitution. Article 1.05, right of the accused. In all criminal prosecutions, the accused shall have a speedy public trial by an impartial jury. He shall have the right to demand the nature and cause of the accusation against him, and to have a copy thereof. He shall not be compelled to give evidence against himself, which goes into the Fifth Amendment of the U.S. Constitution. He shall have the right of being heard by himself or counsel or both, which is your Sixth Amendment right. Shall be confronted with the witnesses against him. If you're looking for any cases that go on the Confrontation Clause, guys, Strickland v. Washington is sort of the seminal case on that. Shall be confronted with the witnesses against him, and there's obviously a Confrontation Clause right in the U.S. Constitution. And shall have compulsory process for obtaining witnesses in his favor. No person shall be held to answer for a felony unless on indictment of a grand jury. So the difference between a misdemeanor and a misdemeanor, you're going to be given an information, which is just the charge against you. Whereas if you are charged with a felony, you're going to have an indictment of a grand jury, although oftentimes the indictment and the grand jury are waived. Article 1.051, right to representation by counsel, and this is going to go into the Sixth Amendment of the United States Constitution. Again, the Sixth Amendment, and then the seminal case on this is Miranda v. Arizona. Sub A defendant in a criminal matter is entitled to be represented by counsel in an adversarial judicial proceeding. The right to be represented by counsel includes the right to consult in private with counsel sufficiently in advance of a proceeding to allow adequate preparation for the proceeding. And then paren B, for the purposes of this article and Articles 26.04 and 26.05 of this code, quote, indigent means a person who is not financially able to employ counsel. Paren C, an indigent defendant is entitled to have an attorney appointed to represent him in any adversary judicial proceeding that may result in punishment by confinement and in any other criminal proceeding if the court concludes that the interests of justice require representation. Subject to subject to subsection C1 if an indigent defendant is entitled to and requests appointed counsel, and if adversarial judicial proceedings have been initiated against the defendant, a court or the court's designee authorized under Article 26.04 to appoint counsel for indigent defendants in the county in which the defendant is arrested shall appoint counsel as soon as possible, but not later than 1. The end of the third working day after the date on which the court or the court's designee receives the defendant's request for appointment of counsel, if the defendant is arrested in a county with a population of 250,000, or 2, the end of the first working day after the date on which the court or the court's designee receives the defendant's request for appointment of counsel, if the defendant is arrested in a county with a population of 250,000 or more. C1. If an indigent defendant is arrested under a warrant issued in a county other than the county in which the arrest was made and the defendant is entitled to and requests appointed counsel, a court or the court's designee authorized under Article 26.04 to appoint counsel for indigent defendants in the county that issued the warrant shall appoint counsel within the periods prescribed by subsection C, regardless of whether the defendant is present within the county issuing the warrant, and even if adversarial judicial proceedings have not yet been initiated against the defendant in the county issuing the warrant. However, if the defendant has not been transferred or released into the custody of the county issuing the warrant before the 11th day after the date of the arrest, and if counsel has not otherwise been appointed for the defendant in the arresting county under this article, a court or the court's designee authorized under Article 26.04 to appoint counsel for indigent defendants in the arresting county immediately shall appoint counsel to represent the defendant in any matter under Chapter 11 or 17, regardless of whether adversarial judicial proceedings have been initiated against the defendant in the arresting county. If counsel is appointed for the defendant in the arresting county as required by this subsection, the arresting county may seek from the county that issued the warrant reimbursement for the actual costs paid by the arresting county for the appointed counsel. Sub D. An eligible indigent defendant is entitled to have the trial court appoint an attorney to represent him in the following appellate and post-conviction habeas corpus matters. 1. An appeal to a court of appeals. 2. An appeal to the Court of Criminal Appeals if the appeal is made directly from the trial court or if a petition for discretionary review has been granted. 3. A habeas corpus proceeding if the court concludes that the interests of justice require representation. And 4. Any other appellate proceeding if the court concludes that the interests of justice require representation. E. An appointed counsel is entitled to 10 days to prepare for a proceeding, but may waive the preparation time with the consent of the defendant in writing or on the record in open court. If a non-indigent defendant appears without counsel at a proceeding after having been given a reasonable opportunity to retain counsel, the court, on 10 days' notice to the defendant of a dispositive setting, may proceed with the matter without securing a written waiver or appointing counsel. If an indigent defendant who has refused appointed counsel in order to retain private counsel appears without counsel after having been given an opportunity to retain counsel, the court, after giving the defendant a reasonable opportunity to request appointment of counsel, or if the defendant elects not to request appointment of counsel, after obtaining a waiver of the right to counsel pursuant to subsections F and G, may proceed with the matter on 10 days' notice to the defendant of a dispositive setting. F. A defendant may voluntarily and intelligently waive in writing the right to counsel. A waiver obtained in violation of subsection F1 or F2 is presumed invalid. Between you and me, never represent yourself. Ever. In any adversary judicial proceeding that may result in punishment by confinement, the attorney representing the state may not, 1. Initiate or encourage an attempt to obtain from a defendant who is not represented by counsel a waiver of the right to counsel, or 2, communicate with a defendant who has requested the appointment of counsel unless the court or the court's designee authorized under Article 26.04 to appoint counsel for indigent defendants in the county has denied the request, and subsequent to the denial, the defendant, Cap A, has been given a reasonable opportunity to retain and has failed to retain private counsel, or Cap B, waives or has waived the opportunity to retain private counsel. F2, in any adversary judicial proceeding that may result in punishment by confinement, the court may not direct or encourage the defendant to communicate with the attorney representing the state until the court advises the defendant of the right to counsel and the procedure for requesting appointed counsel, and the defendant has been given a reasonable opportunity to request appointed counsel. If the defendant has requested appointed counsel, the court may not direct or encourage the defendant to communicate with the attorney representing the state unless the court, meaning the prosecutor, representing the state, unless the court or the court's designee authorized under Article 26.04 to appoint counsel for the indigent defendants in the county has denied the request, and subsequent to the denial, the defendant, 1, has been given a reasonable opportunity to retain and has failed to retain private counsel, or 2, waives or has waived the opportunity to retain private counsel. Sub G, if a defendant wishes to waive the right to counsel for purposes of entering a guilty plea or proceeding to trial, the court shall advise the defendant of the nature of the charges against the defendant and, if the defendant is proceeding to trial, the dangers and disadvantages of self-representation. If the court determines that the waiver is voluntarily and intelligently made, the court shall provide the defendant with a statement substantially in the following form, which, if signed by the defendant, shall be filed with and become a part of the record of the proceedings. And here's the record, or what the defendant has to be provided when you waive your right to counsel. I have been advised this blank day of blank 2024 by the name of court of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. H. A defendant may withdraw a waiver of the right to counsel at any time, but is not entitled to repeat a proceeding previously held or waived solely on the grounds of the subsequent appointment or retention of counsel. If the defendant withdraws a waiver, the trial court, in its discretion, may provide the appointed counsel 10 days to prepare. Subject to subsection C1, with respect to a county with a population of less than 250,000, if an indigent defendant is entitled to and requests appointed counsel, and if adversarial judicial proceedings have not been initiated against the defendant, a court or the court's designee authorized under Article 26.04 to appoint counsel for indigent defendants in the county in which the defendant is arrested shall appoint counsel immediately following the expiration of 3 working days after the date on which the court or the court's designee receives the defendant's request for appointment of counsel. If adversarial judicial proceedings are initiated against the defendant before the expiration of 3 working days, the court or the court's designee shall appoint counsel as provided by subsection C. Subject to subsection C1, in a county with a population of 250,000 or more, the court or the court's designee shall appoint counsel as required by this subsection immediately following the expiration of 1 working day after the date on which the court or the court's designee receives the defendant's request for appointment of counsel. If adversarial judicial proceedings are initiated against the defendant before the expiration of the 1 working day, the court or the court's designee shall appoint counsel as provided by subsection C. Sub J. Notwithstanding any other provision of this section, if an indigent defendant is released from custody prior to the appointment of counsel under this section, Appointment of counsel is not required until the defendant's first court appearance or when adversarial judicial proceedings are initiated, whichever comes first. Sub K. A court or the court's designee may, without unnecessary delay, appoint new counsel to represent an indigent defendant for whom counsel is appointed under subsection C, C1, or I if 1. The defendant is subsequently charged in the case with an offense different from the offense with which the defendant was initially charged, and 2. Good cause to appoint new counsel is stated on the record as required by Article 26.04J2. Guys, we can see that this was amended by Acts 2015, Texas Acts of the 84th Legislature, effective September 1st, 2015, meaning that the right to counsel here under the Code of Criminal Procedure, Section 1.051, has been recently or fairly recently amended. Article 1.052, signed pleadings of defendant. A pleading, motion, and other paper filed for or on behalf of a defendant represented by an attorney must be signed by at least one attorney of record in the attorney's name and state the attorney's address. A defendant who is not represented by an attorney must sign any pleading, motion, or other paper filed for or on the defendant's behalf and state the defendant's address. B. The signature of an attorney or a defendant constitutes a certificate by the attorney or defendant that the person has read the pleading, motion, or other paper and that to the best of the person's knowledge, information, and belief formed after reasonable inquiry that the instrument is not groundless and brought in bad faith or groundless and brought for harassment, unnecessary delay, or other improper purpose. Sub C. If a pleading, motion, or other paper is not signed, the court shall strike it unless it is signed promptly after the omission is called to the attention of the attorney or defendant. Sub D. An attorney or defendant who files a fictitious pleading in a cause for an improper purpose described by subsection B, or who makes a statement in a pleading that the attorney or defendant knows to be groundless and false to obtain a delay of the trial of the cause or for the purpose of harassment, shall be held guilty of contempt. Sub E. If a pleading, motion, or other paper is signed in violation of this article, the court, on motion or on its own initiative, after notice and hearing, shall impose an appropriate sanction, which may include an order to pay the other party or parties to the prosecution, or to the general fund of the county in which the pleading, motion, or other paper was filed, the amount of reasonable expenses incurred because of the filing of the pleading, motion, or other paper, including reasonable attorney's fees. Sub F. A court shall presume that a pleading, motion, or other paper is filed in good faith. Sanctions under this article may not be imposed except for good cause stated in the sanction order. A plea of not guilty or no contest or nolo contendere does not constitute a violation of this article. An allegation that an event took place or occurred on or about a particular date does not constitute a violation of this article. In this article, groundless means without basis in law or fact and not warranted by a good faith argument for the extension, modification, or reversal of existing law. Article 1.053, present ability to pay. Except as otherwise specifically provided, in determining a defendant's ability to pay for any purpose, the court shall consider only the defendant's present ability to pay. That was added fairly recently in 2019, meaning there must have been some case on that. Article 1.06, searches and seizures, which is, I think this is basically just the Fourth Amendment restated. The people shall be secure in their persons, houses, papers, and possessions from all unreasonable seizures or searches. No warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause supported by oath or affirmation. Article 1.07, the right to bail. Any person shall be eligible for bail unless denial of bail is expressly permitted by the Texas Constitution or by other law. This provision may not be construed to prevent bail after This provision may not be construed to prevent bail after indictment found upon examination of the evidence in such manner as may be prescribed by law. We can see this was amended by Acts 2021. I guess that's SP2 is special session. Texas Acts of the 87th Legislature, second special section. That's what I thought that meant. And we can see this was effective 1/1/2022. So this was recently, the language in this section was recently changed. Article 1.08, habeas corpus. The writ of habeas corpus is a writ of right and shall never be suspended. Article 1.09, excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. And that is the 8th Amendment to the U.S. Constitution, restated. Article 1.1, jeopardy. No person for the same offense shall be twice put in jeopardy of life or liberty, nor shall a person be again put upon trial for the same offense after a verdict of not guilty in a court of competent jurisdiction. Article 1.11, acquittal at bar. Acquittal a bar. An acquittal of the defendant exempts him from a second trial or a second prosecution for the same offense, however irregular the proceedings may have been. But if the defendant shall have been acquitted upon a trial in a court having no jurisdiction of the offense, he may be prosecuted again in a court having jurisdiction. Article 1.12, the right of trial by jury shall remain inviolate. Article 1.13, waiver of trial by jury. That's your 7th Amendment. No, it's not the 7th Amendment. Maybe it's the 7th. 7th Amendment is civil trials. Waiver of trial by jury. The defendant in a criminal prosecution for any offense other than a capital felony case in which the state notifies the court and the defendant that it will seek the death penalty shall have the right upon entering a plea to waive the right of trial by jury, conditioned, however, that, except as provided by Article 27.19, the waiver must be made in person by the defendant in writing in open court with the consent and approval of the court and the attorney representing the state. The consent and approval by the court shall be entered of record on the minutes of the court, and the consent and approval of the attorney representing the state shall be in writing, signed by that attorney, and filed in the papers of the cause before the defendant enters the defendant's plea. Sub B. In a capital felony case in which the attorney representing the state notifies the court and the defendant that it will not seek the death penalty, the defendant may waive the right to trial by jury, but only if the attorney representing the state in writing and in open court consents to the waiver. Sub C. A defendant may agree to waive a jury trial regardless of whether the defendant is represented by an attorney at the time of making the waiver, but before a defendant charged with a felony who has no attorney can agree to waive the jury, the court must appoint an attorney to represent him. Article 1.14, waiver of rights. Sub A. The defendant in a criminal prosecution for any offense may waive any right secured him by law, except that a defendant in a capital felony case may waive the right of trial by jury only in the manner presented in Article 1.13 paren B of this code. And then we have sub B here. If the defendant does not object to a defect, error, or irregularity of form or substance in an indictment or information before the date on which the trial on the merits commences, he waives and forfeits the right to object to the defect, error, or irregularity, and he may not raise the objection on appeal or in any other post-conviction proceeding. Nothing in this article prohibits a trial court from requiring that an objection to an indictment or information be made at an earlier time in compliance with Article 28.01 of this code. Article 1.141, waiver of indictment for non-capital felony. A person represented by legal counsel may in open court or by written instrument voluntarily waive the right to be accused by indictment of any offense other than a capital felony. On waiver, as provided in this article, the accused shall be charged by information. Article 1.15, Jury in Felony. No person can be convicted of a felony except upon the verdict of a jury duly rendered and recorded, unless the defendant, upon entering a plea, has in open court in person waived his right of trial by jury in writing in accordance with Articles 1.13 and 1.14, provided, however, that it shall be necessary for the state to introduce evidence into the record showing the guilt of the defendant, and said evidence shall be accepted by the court as the basis for its judgment, and in no event shall a person charged be convicted upon his plea without sufficient evidence to support the same. The evidence may be stipulated if the defendant in such case consents in writing in open court to waive the appearance, confrontation, and cross-examination of witnesses, and further consents either to an oral stipulation of the evidence and testimony or to the introduction of testimony by affidavits, written statements of witnesses, and any other documentary evidence in support of the judgment of the court. Such waiver and consent must be approved by the court in writing and shall be filed in the file of the papers of the cause. Article 1.16, Liberty of Speech and Press. Every person shall be at liberty to speak, write, or publish his opinion on any subject, being liable for the abuse of that privilege, and no law shall ever be passed curtailing the liberty of speech or of the press, in prosecutions for the publication of papers investigating the conduct of officers or men in public capacity, or when the matter published is proper for public information, the truth thereof may be given in evidence. In all indictments for libels, the jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. Article 1.17, Religious Belief. No person shall be disqualified to give evidence in any court of this state on account of his religious opinions or for the want of any religious belief, but all oaths or affirmations shall be administered in the mode most binding upon the conscience, and shall be taken subject to the pains and penalties of perjury. Article 1.18, Outlawry and Transportation. No citizen shall be outlawed, nor shall any person be transported out of the state for any offense committed within the same. Corruption of blood, etc. No convictions shall work corruption of blood or forfeiture of estate. Article 1.20, Conviction of Treason. No person shall be convicted of treason except on the testimony of two witnesses to the same overt act, or on confession in open court. Privilege of Article 1.21, Privilege of Legislatures. Senators and representatives shall, except in cases of treason, felony, or breach of the peace, be privileged from arrest during the session of the legislature and in going to and returning from the same, allowing 1 day for every 20 miles such member may reside from the place at which the legislature is convened. Article 1.23, Dignity of the State. All justices of the Supreme Court, judges of the Court of Criminal Appeals, justices of the Courts of Appeals, and judges of the district courts shall, by virtue of their offices, be conservators of the peace throughout the state. The style of all writs and process shall be, quote, the state of Texas. All prosecution shall be carried on in the name and by the authority of the state of Texas, and conclude against the peace and dignity of the state. Article 1.24, Public Trial. The proceedings and trials in all courts shall be public. Article 1.25, Confronted by Witnesses. The defendant, upon a trial, shall be confronted with the witnesses, except in certain cases provided for in this code where depositions have been taken. Article 1.26, Construction of this code. The provisions of this code shall be liberally construed so as to attain the objects intended by the legislature, the prevention, suppression, and punishment of crime. Article 1.27, Common Law governs. If this code fails to provide a rule of procedure in any particular state of case which may arise, the rules of the common law shall be applied and govern. Okay, guys, this has been the Code, Texas Code of Criminal Procedure, General Provisions, Section 1.01 to 1.27, the General Provisions. In the next video, we're going to go through Chapter 2, which is Section 2.01 to 2.35, the General Duties of Officers. Guys, my name is Reese, and this is Law by Reese, bringing you a playlist here of the Texas Code of Criminal Procedure 2023 edition.